Welcome to the Boomer Buzz, the show that focuses on issues of interest to the 60 and over crowd, both here on Long Island and across the country. Listen as experts keep you informed about the latest health solutions, financial options, and lifestyle choices, both for senior citizens and their families. Now, here are the hosts of the Boomer Buzz, Dr. Lamar Stanford and Patricia Stanford, Corporate Wellness Consultant, on the voice of Nassau Community College, 90.3 WHPC.
Welcome to the Boomer Buzz, where each week we'll give you the buzz on how to stay healthy, wealthy, and wise after the age of 60.
Today we're speaking with attorney Kim Christian, who is an elder law specialist here on Long Island with the Russo Law Group.
Welcome to the show, Kim. It's an honor to have you with us, an expert in this field where the law seems to be getting more complex every day.
Now, maybe we could start out by defining, Kim, what is elder law?
Oh, well, first of all, thank you for having me. I'm thrilled to be on the show. And as you said, I am a partner and attorney with Russo Law Group. We're elder law, estate planning, and special needs attorneys with locations here on Long Island and also in Manhattan. And I love your question, what is elder law? Because that really is the bottom line of what we're talking about. So elder law is an area of legal practice that specializes in the aging population. Elder law encompasses estate planning, long-term care planning, and tax planning altogether.
Now, one question, can an ordinary attorney be competent in this area, or is it so complicated now that a specialist really needs to be used?
It's so critical to see someone who's knowledgeable and whose area of practices focuses on elder law. Elder law is a detailed area of practice with significant nuances to it. So knowledge of eligibility requirements of government-entitled programs is essential. The practitioner has to know the client and what their personal goals are, because the personal and financial consequences can be critical. So the practitioner needs to be well-versed in all areas to provide a valuable service.
That's my assumption, that it's getting so complicated. You have to have somebody like yourself to guide them through the maze of government regulation. Yeah. Maybe we can start. I think the most basic part of elder law is everybody should have a will, right?
That's correct. Everybody should have a will. Basically, a will sets forth in writing your testamentary desires, how you want your assets to go when you're no longer with us. And a will is so critical because I consider it to be like a roadmap. It sets forth your intentions without ambiguity. And as we know, when there's ambiguity, there's rules for interpretation and room for interpretation. So you want to be as clear as possible to make sure that your intentions are met at the end of your life.
So is that one of the first things you ask a client when they come in? Do you have a will set up?
Well, I think the first thing I ask the client is, what are your goals for this meeting? Because it's important to have an all-encompassing, comprehensive plan. So someone may say, you know what, my goal is to have a will. Or someone may say something even a bigger picture, like my goal is to embark on long-term care planning, or I want to make sure a loved one is protected. There's so many different machinations of what a person's goal is. I think the practitioner has to get the big picture first. So I ask what their goals are, and often their goals will include having a will.
Can a person use, there are these online legal mills like LegalZoom. Can a person, he's got a very simple estate. Could he use that, or is it getting complicated enough that you could get blindsided if you used some standard form will like that to pull off the internet?
Yeah, it's a complicated area of law, so it's not recommended. Yeah. The complexity of this area warrants a knowledgeable elder law attorney, because you want to make sure that you get down your intentions and that it's clear and there's no ambiguity and that your goals are actually met. So it's not recommended, something like a form.
Now, I was just going to touch on the base of financial. What, like if somebody was to come to your office, what would be their initial cost for, say, a half-hour consultation?
Right. So to answer your question specifically, in our office, we charge an initial fee of $475 for an hour and a half. But it's important to identify what you're getting when you go to the consultation. So, for example, in our office, we will review your situation in its entirety. We'll review your existing legal documents. We'll create an action plan with all the steps and recommendations to create a full and comprehensive plan for the individual or individuals. Some attorneys may offer a free initial consultation, but that may be met with more of a general consultation with a few takeaways. So it's critical that the client understand what they're going to expect at the first visit. Am I going to get a full comprehensive plan with details, or is it just sort of a meet and greet where we stick to generalities? Mm-hmm. In our office, we do charge a fee, but you get a full comprehensive plan at the end.
And an hour and a half, that's a bargain on today's fees, yes.
It is.
Now, one other point I'd like to touch on is the power of attorney. When should we have a power of attorney drawn up, and how do you choose a good person to act in this capacity?
Yeah, a power of attorney is one of the most important legal documents. The power of attorney is a document that allows you to designate agents to make financial decisions if you need or want them to. It takes no power away from you, but in the event you want someone or need someone to make these financial decisions for you, then you want to designate a person in writing that you trust and is going to carry out your financial goals as you would have. So to answer your question, how do I pick one? It really depends on who is someone that you trust and who is knowledgeable and has a certain proficiency in finances that they can get you to the place you need to be.
Now, an attorney can act as a designate in a power of attorney, can he not, or can she not?
Yes, they can.
But they have to be paid for their time, whereas you might be able to get a family member to act in that capacity and they would incur fewer fees, I suppose, right?
That's correct. So whenever a client will come to me and they are in need of a power of attorney, we'll first discuss who in their world do they feel can act as agent under their power of attorney. And we talk about it and we make sure that they're comfortable with that. In that event, they can have the power of attorney actually receive compensation, or they don't have to at all. A lot of times they won't, but there are cases where they can. In the event an attorney or another professional acts as their power of attorney in that capacity, it is likely that they will have fees associated with it.
Okay, you're listening to the Boomer Buzz on the voice of Nassau Community College, 90.3 WHPC, and our guest today is elder law attorney Kim Christian with the Russo Law Group here on Long Island, and in Manhattan, we just found out too. So, Kim, in the healthcare area, what are the legal documents that a senior should have prepared and in place?
Right. So in the healthcare area, you want to have something called a healthcare proxy, which includes a HIPAA authorization in it, as well as a living will. A healthcare proxy is a document that nominates an agent or agents to make healthcare decisions on your behalf. So it can be anything, should she have this medication, should she have this surgery, all the way to end-of-life decision-making. So again, it's going to be want to be someone who you trust and who is aligned with what your goals are, because essentially they will be speaking for you in the event you can't. Within the healthcare proxy or as a freestanding document, you also want to make sure that you have a HIPAA authorization in there. That way the person is not making any decisions in a vacuum. It gives them the legal right to review your medical situation, review your medical records, speak to all your healthcare professionals. That way they can come to a conclusion that's best suited for you. And the third document that I mentioned is something called a living will. A living will is a very personal document, and it sets forth your intentions about end-of-life decision-making. So essentially it says, if I am ever in a persistent, vegetative state, my brain is not working or my heart is not working, and doctors agree that there's no chance of recovery but for these extraordinary life-preserving measures. This document says, please, at that point, let me go peacefully. And it's very important in creating clarity, A, for the healthcare proxy to make such a profound decision like that. And also, it's a legal document that makes sure that your intentions are followed.
Okay, so that's like a healthcare directive for the family and for the loved ones.
Yes, that's a perfect way of explaining it.
Okay, so the living will is sometimes called healthcare directive, is that correct?
That's right.
Okay.
These are all what's called advanced directives. You're setting up in advance, and it's setting forth your direction.
Now, I notice that when anybody is admitted to the hospital these days, they ask if you have these things in place, and they're more than willing to get you forms if you don't have them. So I would imagine that over the years there have been some horror stories where people have not been protected health-wise and did not have these proxies in place and then needed them.
Yeah, we've seen several stories where perhaps someone's intentions were not followed as to what they would have want, or perhaps maybe the individual that they did not anticipate being their healthcare proxy was, because it wasn't done in advance. So as a result, again, when there's ambiguity, there can be issues that arise. For example, fighting over a person's care, ending up needing, a guardian appointed, which sometimes can be a long, procedure. So you just, again, want to make sure that it's you that is designating what you want so that you can make sure your intentions are fulfilled.
Okay. A couple of weeks ago on our show, we had a doctor on, Dr. Melissa Armstrong. She talked about end-of-life issues from a medical perspective, and she talked about how these days there are so many non-traditional families that she felt that this area was so important for people to have discussions about before you need them. It's important to have these.
I couldn't agree with her more.
Yeah,
it is so important. Yes.
This paperwork taken care of. Mm-hmm. So let's talk a little about end-of-life events. Who should know how a senior wants to be cared for in the last years of their life? Do they have that conversation with their family members, with their friends? What do you recommend?
Right. To the extent the person is comfortable with it, I always recommend having a conversation with your family members, if that's what you're comfortable with. I recommend having the conversation with the individual who is going to be the agent under your healthcare proxy. The clearer you can be, notwithstanding what's in the document, but also verbally, the clearer your intentions will be. So I recommend having that conversation with the agent under your healthcare proxy, and if the agent isn't a family member, have it with your family as well, because it puts essentially everybody on notice what you intend to have happen. And you should have a conversation with your healthcare provider, your doctors, the people that you see most often in the healthcare profession.
And should all of that be documented to avoid confusion? So you should also communicate that to your attorney as well, I guess.
Yes, and that goes back to, one of the initial statements I said. And what are your goals? Because when you seek out an elder law attorney, when you have a consultation, you want to have an overall full picture of what your goals are. And that includes making sure that everybody's on the same page, not only financially or with a will, but also with your health care needs and what your health care wishes are. So communicate everything with your elder care attorney. The more you communicate, the better they can help you.
Now, that's wonderful. I'm Patricia Stanford, along with my husband, Dr. Lamar Stanford, and our guest today is elder law attorney Kim Christian with the Russo Law Group here on Long Island and in Manhattan. You are listening to WHPC 90.3, the voice of Nassau Community College. We'll be right back.
You took the first step and quit smoking. But even former smokers may still be at risk for lung cancer. That's why SaveByTheScan.org wants you to know about a new low-dose CT scan that can detect lung cancer early. It takes only 60 seconds and could save your life. You took the first step, now take the next. Visit SaveByTheScan.org for a simple quiz to see if you're eligible and talk to your doctor about screening. SaveByTheScan.org is brought to you by the American Lung Association's Lung Force Initiative and the Ad Council.
Welcome back to the Boomer Buzz on the voice of NASA Community College, 90.3 WHPC. I'm Dr. Lamar Stanford, along with my wife, Patricia. And our guest today is elder law attorney Kim Christian. She works with the Russo Law Group here on Long Island, and they have offices in Manhattan. Now, Kim, could we get into another area of elder law for our audience? Like, what is probate? Maybe a lot of them have heard the term, but they're not familiar with it. Can you just kind of maybe give them a general idea when you use probate and what's it about?
Yes. So probate is the legal process of submitting to court for approval the last will and testament of someone who's passed away. So the court validates the will and legally appoints the executor named under your will. And as an executor, he or she is responsible for carrying out the affairs of the estate, which includes collecting the assets, paying debts such as taxes, and distributing the estate assets in accordance with the will. So many people want to avoid probate, and there's certain planning options to do that would assist in doing so.
That's anytime you mention court being involved, that's an added cost, isn't it?
Yeah, there are times due to certain circumstances that probate can take a considerable amount of time and can be expensive. So an elder law attorney can help expedite the process and hopefully help keep the fees down, but oftentimes our clients will aim to actually even avoid the need for the probate.
In fact, how can a couple avoid the cost of probate when one spouse dies? Is that easily done, or is that difficult?
Well, when speaking to your elder law attorney, and probate is one of your goals, you want to make sure that your elder law attorney is aware of it so they can make the recommendations with that in mind. So generally speaking, you can avoid probate by having assets jointly held with one another, or you can have the asset have a beneficiary on it, or you can have it held in a trust. And it can be a combination of all of these options, but as long as all of the assets have one of those three things, then typically you would avoid probate.
Okay.
So just by identifying that as a goal, your elder care attorney can help you make sure that's all in place to avoid it.
Okay. Now, one thing I think my wife and I do is we have our both names on our bank accounts and on the property that we own. So could we avoid probate by simply having that in place if one of us was to pass on?
That's an excellent example. So the three ways that I mentioned avoiding probate was having assets held jointly, having assets with a beneficiary, or having assets held in a trust. And in your example, you said all of our accounts are held jointly together, and our real estate is held jointly as well. So essentially, when the first of you is no longer with us, then by operation of law, the assets will pass to the surviving spouse because you have assets that are jointly held. It's important to be mindful that after the first spouse has passed away, now at that point, the surviving spouse has the assets in their name individually. So at that point, you need to talk to your elder care attorney and make sure you restructure your assets in a way if avoiding probate is one of your goals going forward.
Okay, thank you. Can we maybe talk about some financial considerations here? In fact, when you introduced yourself, you said tax and other financial implications were really important these days for estate law planning. How can you minimize taxes and other expenses upon death?
Again, you want to identify when you come in that estate tax planning is one of your goals. And don't worry, it's not all on your shoulders. A seasoned elder law attorney will bring this up to you. They'll say, okay, what are your goals? For example, estate tax planning, avoiding probate, long-term care planning. So now if you're talking about avoiding taxes, you're going to talk about all different kinds of taxes. So one example would be estate taxes. Estate taxes, some people refer to as death taxes. So how much money can an individual pass away and have in their estate and still avoid paying an estate tax? And the answer to the question depends on whether you're talking about the New York State estate tax exemption or the federal estate tax exemption. So for 2019, commencing January 1st of 2019, the New York State estate tax exemption amount is $5,740,000 per person. So as long as you are under that amount, then you will not pay New York State estate taxes.
Okay. Can I just ask you another question? When should a financial advisor be brought in to be part of the team?
The elder law attorney should identify for you when a financial advisor is necessary by reviewing the client's entire situation. So in our office, for example, we counsel by understanding the client's entire picture and all of their goals, and we'll involve their financial planner, accountant, geriatric care manager to make sure they get the most comprehensive plan. So we will review your situation and say, you know what, it's important that you have a financial planner be on your team for multiple reasons, and if they already have one, we'll make sure that they're a part of that plan.
You're listening to the Boomer Buzz on the voice of Nassau Community College, 90.3 WHPC. And our guest today is elder law attorney Kim Christian with the Russo Law Group here on Long Island.
In kind of a summary of some of the things we've talked about, Kim, can you give us a list? I know how, like 1, 2, 3, 4, 5, and a list of documents that all baby boomers should have ready in case of serious health issues arising. Something that they'll eventually use, say, if they lose capacity or confused, they get confused or that type of thing. We started off with the will, didn't we, and some of the other things. Is there kind of a little list that you would give a client when they came in and said, okay, we need to touch base with these?
Yeah, I would call them the 5 must-have legal documents. It doesn't mean that we won't recommend something else, but if you're looking for that foundation to make sure you have it in place, I would recommend you having a durable power of attorney. I'd recommend a healthcare proxy, a living will, a last will and testament, and a trust. Generally speaking, those are your 5 must-have legal documents. There'll be some variables within it, but that would be a list I would give.
Now, you mentioned trust. I skipped over that because trusts seem to be very complicated. The law's always changing. You always have to go back to your attorney when something happens. Is a trust an easily used document, or is it a little bit complex?
Well, there's complexities in setting up the trust, so you certainly need to see an elder law attorney to make sure you get the proper kind of trust that meets your goals. Once the trust is set up, it is fairly flexible, and you are able to manage it, assuming you understand the terms of it. So when you meet with your elder care attorney, identify what your goals are. For example, you may say, my goal is just to avoid probate. Can I have a revocable trust for that? In that circumstance, the answer perhaps is yes. And we set up a revocable trust. We make sure we review everything with the client so that they understand the terms and how to administer it.
Now, can we just maybe explain, Kim, that a revocable trust means that you can change your mind, can't you?
Correct. You can change your mind at any point.
Right.
You can be the trustee. You have unfettered access to it.
Right.
Some of our clients come in with a different goal. They say, you know what, avoiding probate is on my list, but I also want to layer in health care and asset protection to it. And they may create an irrevocable trust or an irrevocable trust. And in that instance, again, the elder care attorney should go over the mechanics with you, make sure you fully understand what the trust says and how it works, And of course, you should have an ongoing relationship with your elder care attorney and have that comfort level to call or come in and ask any questions about the administration of the trust. That way it leaves any sort of concern about the complexities of the trust. It alleviates those concerns because you have someone to reach out to.
When would a trust be used? Can you think of a specific application of the trust?
Well, I can think of a few. So, for example, oftentimes our clients are setting up what are called Medicaid Asset Protection Trust or irrevocable trust because they're concerned about needing long-term care in the future, and they don't necessarily have the financial means to pay privately. As we know, long-term care is quite expensive. So they will set up an irrevocable trust, transfer some of their assets to the trust, and after a period of time, those assets will be protected if they require long-term care, either at home or in a nursing facility. So that's a specific reason a person might set up an irrevocable trust. Other specific reasons that people might set up an irrevocable or revocable trust is if they want to avoid probate. And there's different reasons for avoiding probate. For example, I may have properties in multiple states, and I don't want to have to go through this process in different states or I don't want my trustee to go through the process of probating in different states after I'm not here. Or there may be situations where we're perhaps disinheriting someone or leaving less assets to one person versus another, and we want to avoid the court arena and, to the extent possible, avoid conflict. So we may do a trust in that situation as well. So there's really many different reasons why people set up trusts, and again, it just goes back to expressing your goals and the elder law attorney making sure that they hear you out and understand what they are.
Excellent.
I think that most of us have heard over the years about squabbles between siblings and heirs when a person's estate is distributed, and it seems like consulting an elder law attorney is the way to go so that you're planning for a smooth transition in the legal area. So we want to thank our guest, elder law attorney Kim Christian with the Russo Law Group here on Long Island. This has been so interesting. We didn't get to about half of our questions, and we hope that you'd be willing to come back again to discuss some other legal issues with our Boomer audience.
Absolutely. I'd be honored to come back.
That's terrific. Thank you so much. I'm Patricia Stanford, along with my husband, Dr. Lamar Stanford, and you've been listening to the Boomer Buzz on 90.3 WHPC. This show will be available as a podcast on iTunes, Android Podcasts, Spotify, and Spreaker.com. If you have any comments, email them to us anytime at whpc@ncc.edu. Thank you for listening to the Boomer Buzz here on the voice of Nassau Community College, 90.3 WHPC.